So we're in the middle of 2024 and there's a ton of conversation around what's going to happen in the next 18 months related to estate tax changes. Today we're going to talk about what's the most important, the most popular estate tax strategy that you're going to see in the next 18 months that every single wealthy family and individual needs to know about. So there's a variety of different ways that you can reduce your estate tax. Gifting is probably the most popular strategy. You can sell assets, you can leverage life insurance to be able to pay off estate tax. So there's different ways to minimize that, pay it off. Different attorneys have different strategies, but probably the most popular strategy is to gift assets. And there are different techniques that the IRS recognizes, or sometimes you'll hear attorneys say they sanction it, meaning that it's actually written out in the tax laws. And just because it's not written to the tax laws doesn't mean it's not a legitimate strategy, but there's certain strategies that the IRS likes and therefore they include it in the tax laws and the regulations and explanations. And so a lot of times you'll see that. The most popular strategy in 2024 that you're going to see over the next 18 months because of the changes in U.S. estate tax laws is what's called the SLAT. It's a Spousal Lifetime Access Trust, which is an irrevocable trust. I'm going to explain that more here in a second, but real quick, I'm going to recap what's going to happen with the estate tax laws in the next 18 months. So today in 2024, every individual person is allowed to pass up to $13.61 million in assets free of any estate tax. So up to that amount is what's known as your exemption. That's what's exempt from having to pay, exempt from being subject to estate tax. Anything over that threshold, that $13.61 million, is going to be subject to estate tax. So you have this exemption amount that you're able to use during your lifetime as well as upon your passing. So that's one of the things that's really important to remember with estate tax. It's not just what happens upon the moment that you die. The IRS actually looks at what you're giving away during your entire lifetime. It's a lifetime transfer tax is the correct way to really look at it. So during your lifetime, you're able to give up to $13.61 million in assets free of any estate tax. That amount is indexed for inflation every single year, okay? So in 2025, it's going to likely be more as it increases each year because of inflation. And the Treasury lets us know once we get closer to this new calendar year what it's going to be. So next year it could be 14 plus million, maybe 15 million, we don't know. So because of the way that tax laws are currently written and the way that they were passed in previous years, particularly in 2017, the current exemption amounts are set to go back down to $5.5 million effective January 1st, 2026. But what this does mean is that we have time to do some planning. So when it goes back down, it's going to go back down to around 5.5 million. It'd be indexed for inflation. So it'd be around 6 or 7 million. If you watch some of my videos, you've heard me talk about this. What's unique about all of this is that you actually can lock into this $13.61 million in exemption that you have today. So if you start gifting assets today, then you can go ahead and get locked into that. And so that's why the next 18 months, you're going to see a ton of people using what's called the Spousal Lifetime Access Trust, or SLAT. There's different ways to set up a SLAT, and I'm just going to give you kind of the basic overview so you can have a working knowledge of what this really is. So it's an irrevocable trust. And typically, in my examples, I pick on men because men usually, they marry someone who's younger, often, and then also they have lower life expectancies, so they'll pass away before their wife. So a man, husband, sets up an irrevocable trust for the benefit of his wife. That's pretty much in its simplest terms what it looks like. Husband sets it up for benefit of his wife. He can then make it benefit his children. It could be that it benefits the wife and children all at the same time. Often you'll see that it benefits just the wife, and then once she passes away, it will go then to benefit the children. You can make it a very, very loose, completely discretionary distribution standard, or you can make it a health, education, maintenance, and support that's known as HEMS. You can tighten it up for creditor purposes. There's different ways to approach that. But usually you'll see it set up for the benefit of the spouse. And then the trustee on that trust can also be the spouse. So if the husband sets it up for benefit of the wife can actually be trustee on that. She can make decisions regarding the investment of those assets, selling assets, how they're used, what to buy, and also when she's going to make distributions to herself or to the children if they're also beneficiaries during her lifetime. So the concern about all of this is what happens to that spouse, to the husband who sets this up. He's having to give up these assets and put them in trust. So let's talk about two things. One, why is he putting them in trust? So he's putting them in trust. He's using his exemption amount. Let's just say he puts up to $13.61 million in assets. Let's say they're securities or brokerage account. He puts that in trust for the wife. Those assets are typically going to appreciate over time. Any of that appreciation that happens in that trust is going to be free of any estate tax because he went ahead and he walked into his $13.61 million exemption. He used all of it, right? And so if he passes away in many years from now, he's going to be subject to what it was today in that year that he made those gifts, not in say 5 years or 10 years or 20 years, if the laws end up related to the exemption end up being much lower. So he's taking advantage of this exemption. I've heard people say that exemptions are currency, and I think that's a good way to really look at this. So he goes ahead, he uses the exemption, he puts it in an irrevocable trust. Because it's an irrevocable trust, it's an estate tax planning vehicle. Any of that appreciation of those assets are going to be free of any estate tax. So even though when he passes away, he put $13.61 million of securities in there, the fair market value on the day he died could be, say, 40 million or 80 million. It doesn't really matter. But point is, he's only going to be accountable for that $13.61 million, which is under the exemption amount. Therefore, he's not having to pay any estate tax on that 80 million. They've gotten it out of their individual name. So that's really the name of the game. Get assets out of your individual name into the name of trust. You'll also see this used in conjunction with maybe a limited family partnership or family limited partnership or a family limited liability company, an FLLC, an FLP, where people are giving an interest in these structures to a trust. So there's different ways to look at it. But in simplest terms, it is literally just an irrevocable trust that one spouse sets up for the benefit of the other spouse. The spouse who sets it up, they do have some concern about, what if my spouse dies, or what if we get divorced, or, I don't have access to this money anymore. And that is a legitimate concern. However, what you'll hear commentators and attorneys and other planners talk about is how that spouse has indirect access to those funds. So even though he sets it up for the benefit of the spouse, his wife, then that wife can, take distributions to herself and take the husband on vacations or buy a new home or buy a new car. She can use that money as well on him, but either way, it's in trust, it's outside of their individual names. So he does have the potential to lose control over that. I mean, he will lose control over that. And if there's a divorce, you could use what's called a floating spouse provision, where it doesn't name a specific spouse, but it just says that your spouse is the beneficiary, and if there were a divorce, then that spouse would no longer have benefit from that trust, and then the kids would benefit. So there's different ways to account for that and tighten it up and make sure that you have a lot of flexibility, and that even though you're giving up enough control to get it out of your individual name for purposes of reducing your estate tax. So 2024, we got next 18 months, you're gonna see a lot of spousal lifetime access trusts done. So it's something to think about.